What are the types of custody? In the state of California, there are two distinct types of custody. There is legal custody and there is physical custody. First, with legal custody. Legal custody is decision-making power. The health, the school, the religion, making decisions for a child and their upbringing. So having joint legal custody means that both parents must work together to determine these decisions, while having sole legal custody allows one parent to make these decisions unilaterally. Number two is physical custody. And just as it sounds, physical custody is who actually physically has the child. This can be anywhere from 50-50 to 70-30. Typically, if you have joint physical custody, that means each parent has greater than 30% timeshare. If it's anything less than 30% timeshare, the judge may order sole physical custody to one parent with a specific visitation schedule to the other. What is the best interest of the child? The best interest of the child is laid out in the 3000 section of the Family Code. And what that means is the judge is going to take a look and determine what serves the children the best in a specific situation. Who can provide for their physical and mental health, their well-being, who can support them in school and extracurricular activities. The judge is looking to put the child in the best position possible to succeed given the situation. Is it possible to change custody orders? The short answer is yes. First, an initial custody order is a temporary custody decision and there requires no change in circumstance, just simply the filing of an RFO and presenting the case to the judge as to why custody should be modified. Now, if you have a judgment or a final order in regards to custody, there's required to be a material change in circumstance. Now, what is a material change in circumstance? I think it's easiest to explain by giving examples. The easiest material change in circumstance would be the child's age. If an order was made when a child was 3 prior to school, well, a material change in circumstance is the child is now in school. There also may be changes such as moving homes or changing in living situations, such as additional people living in the home. So the judge is looking for a major change in the child's life or with one of the parents to grant a change in custody once there's been a judgment in place. Is it possible to move away with my child after divorce? The short answer is yes, it is possible, but there are requirements that must be met. Once a case has been filed, once you have a parentage case or a divorce case involving children, there's what's called the ATROS in place, Automatic Temporary Restraining Order. And the automatic temporary restraining orders don't necessarily impact the parents in regards to custody, but it restricts the movement of the child. In the state of California, if you want to move more than about 20 miles away from your current location, or even if you would move and it would create a material change in circumstance, you're going to need written approval of the other parent or a court order. If you're struggling or having issues in California Family Court with your child custody, click the link in the description or call the number in the description to schedule a free case evaluation with our team here at Real Fathers Rights, where we can go over the specifics of your matter and determine how we can help you successfully navigate the child custody process.